Recorded live.
All right, welcome everybody. Tonight is Wednesday night. It's 8 p.m. Eastern Time, and we are ready for another episode of NTT, New Trust Technology. If you're a first-time caller, welcome to the call. We're excited to have you tonight. Before we start, I'm going to read our Notice Acknowledgement Agreement. This show and our document is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making legal decisions. You will not use any of this information for making a legal decision or performing a legal procedure, and it's not a substitute for legal advice and or guidance by a licensed attorney. The show and our documents are for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of the herein reference, and has no interest in any of the issue referenced therein and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaison to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and our show recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more. First multiplication or impairment per Christian Walters' discretion. Thank you for your understanding. And with that said, I would like to turn it over to Christian Walters. Christian, welcome to the show.
Hi, man. How are you doing?
I'm great. How are you tonight?
Well, not too bad. Not too bad. Ready to get going.
Yeah, it's great to have you back.
So I guess we're starting on page 338, where we left off, under Section 3 on the Lewin book, A Practical Treatise on the Law of Trust. So that's page 338, Section 3, and it's entitled, What Persons Taking the Legal Estate Will Be Bound by the Trust? Number 1, general rule. The universal rule as trusts are now regulated is that all persons who take through or under the trustee, except purchasers for valuable consideration without notice, shall be liable to the trust. Number 2, the heirs and executor bound by the trust. On the death of the trustee, the heir, executor, or administrator becomes the legal owner of the property, but as he merely represents the ancestor, testator, or intestate, he takes in the same character and is therefore bound by the same equity. Number 3, so the divisee. So if the trustee divides the estate, the divisee takes the estate subject to the trust. And number 4, and assigns by an act inter vivos. So all the signs of the trust by acts inter vivos, except purchasers for valuable consideration without notice, will be bound by the trust. And 5, so assigns in the post. Assigns in the post, that means in the past, or by operation of law, or also invested in the character of the trustees, as if the trustee marry, the wife is at law entitled to her dower, and if a female trustee marry, the husband is at law entitled to his courtesy. But in equity, both the dowers and the tenant by the courtesy are compellable to recognize the right of the sisti trust. So a creditor of the trustee extending the trust estate under an illegit or taking a trust chattel by writ of execution, by the same rule, the creditor's trustee under a bankruptcy are made subject to the equity. Number 6, forfeiture. If the trustees of the trust commit a forfeiture, the lord, as he succeeds into the identical estate of the forfeiter, must take the property with all the engagements and encumbrances attached to it, is therefore liable to the trust. In the case of a forfeiture to the Crown, it was formerly held that there was no equity against the Crown, but in modern times the equity was admitted, though the precise nature of the remedy was never distinctly ascertained. Number 7 is cheat. The lord taking by his cheat stands on somewhat different footing, but he does not take through or under the trustee at all, and he is not an assign of the trustee either in the per or post, nor does he in a forfeiture succeed to place the trustee, but claims by the title paramount of his own by virtue of a condition originally annexed to the land and wholly independent of the creation of the trust. And I believe my opinion that is where things diverged and where everything got really mixed up and misconstrued from that point on. Because I really believe at that point, when the Lord can take as his cheat, then really you have no rights. And I believe that's where it went wrong. So continuing on, Burgess versus Wheat. Lord Mansfield was of opinion, however, in Burgess versus Wheat, that a trust ought to be binding on the Lord, and cited the opinion said to have been expressed by Lord Chief Justice Bridgeman and Sir John Trevor. But as to the words attributed to the former, it appears from his own notebook that they were never spoken, and the observations of Sir John Trevor was at the utmost a mere obiter dictum. Sir Thomas Clark, on the other hand, who assisted Lord Mansfield in the case of Burgess versus Wheat, thought that the Sedekey Trust was no more relievable against the Lord by his cheat than against the sale by the trustee to a purchaser without notice. And Lord Nottington's inclination was apparently the same way, though as a point was not necessarily involved in the question before him, he declined to conclude himself in any express and direct opinion. It is clear that the Lord was not bound by the use. However, it must be admitted that in modern times the courts have acted on a more liberal principles, and it has been actually decided that where the fee out of which the mortgage term has been carved as cheats to the Lord, he may redeem, and if the Lord may take the benefit through the tenant, it seems to follow that he must sustain on an onus. Indeed, an opinion that the effect be enunciated by the Lord James when Vice Chancellor, and also by an equity court in Ireland. So now that the Acts 13 and 14 of Victoria, section 60, and 44 and 45 Victoria, subsection 41, to be noticed presently, have been passed, and it is unlikely that the point will ever call for a decision. Number 8, copyholds. In copyholds there is, properly speaking, no such thing as a cheat. The freehold and inheritance are vested in the lord of the manor, and the tenant has no claim but according to the entry on the court roll. If the tenant be a trustee, no trust appears on the roll, and there can be no pretense for charging the lord in an equity to which he never assented. But if a surrender be made upon the trust, either expressed or referred to on the roll, the lord is stopped by the evidence of his will and cannot afterwards claim in contradiction to his grant. Number 9, customary freeholds. Customary freeholds held not at will of the lord, but according to the custom of the manor, stand on the same footing as copyholds in reference to his cheat. For it is now established that customary freeholds are in fact copyholds, but of a privileged character. Number 10, equity of redemption. A distinction has been taken by Lord Hale between the trust and equity of redemption. Quote, a trust, said his lordship, is created by the contract of the party, and he may direct as he pleases, and he may provide for the execution of it, and therefore one that comes in the post shall not be liable to it without express mention made by the party. Of the rules of executing a trust have often varied, and therefore they only are bound by who comes in privity of estate, but a power of redemption is an equitable right inherited in the land and binds all persons in the post or otherwise, because it is an ancient right which the party is entitled to in equity. But upon this distinction there must be observed that even in a trust where at the present day bind persons who take derivatively from the trustee, though in a post and notwithstanding an equity of redemption amounts to what Lord Hale calls a title, there seems to be no reason why the case of his cheat, the lord, who takes by title paramount, shall be bound by an equity of redemption any more than by a simple trust. Next, Viscount Dow and versus Morse. In the late case, however, the distinction between an equity of redemption and a trust was observed upon, and the court expressed an opinion that the lord who was in by his cheat would be bound by equity of redemption and not by a trust. Number 11, real estate is cheating in assets in hands of the lord. The 3rd and 4th W4, section 104, which subjects a person's real estate to the payments of his simple contract debts, annexes the quality of the assets to the estate itself and subject to the rights of alienation by the heir or divisee, and creates a charge on the estate for the benefit of the creditors, and has been held that the debtor's estate and his assets even in the hands of the Lord, taking by his cheat. Next, section 12, 13 and 14th Victoria, section 60. The law relating to forfeiture and escheat of trust estate, except so far as it illustrates general principles, has now, by the interference of the legislature, become of little importance, for by 13 and 14 Victoria C. 60, it is enacted in effect by section 15 that in case of failure of the heirs of a trustee, the Court of Chancery shall have power upon summary application to transfer the legal estate. And by section 46, the trust property shall not escheat or be forfeited by reason of the attainer or conviction of any offense of the trustee. And by 44 and 45 Victoria section 41, subsection 30, in the case of the death of a trustee after the 31st of December, 1881, the legal estate in the realty devolves upon the legal person representative of the trustee and may be disposed of and dealt with by him as if it were a chattel real. 13. Outlawry of the trustee. If a trustee be outlawed for treason or felony, the outlawry amounts to conviction, and the ordinary consequences of forfeiture or escheat are averted by the above act. But on the outlawry, an indictment for a misdemeanor or an impersonal action is not equivalent to a conviction of the offense, but merely a contempt of court, punishable by forfeiture of the life rent of the outlaw's lands and of his chattels, real and personal, absolutely, and in this case, therefore the statute does not apply. Next, section 14. A deceasor not bound by the trust. A deceasor is not an assign of the trustee, either in per or post, for he does not claim through or under the trustee, but holds by a wrongful title of his own and adversely to the trust. The first resolution of Sir Moyle French case was that a deceasor was subject to no trust, nor any subpoena was maintainable against him, not only because he was not in the post, but because the right of inheritance or freehold was determinable at common law and not in chancery. Either had the City Key Trust, while he had his being, any remedy in the case. And we may add that the authority of Lord St. Leonard's, who, in his edition of Gilbert on uses, observes, quote, "At this day, everyone who is bound by a trust who obtains estate without a valuable consideration, or even for a valuable consideration, if with notice, unless perhaps the Lord by his cheat, but persons claiming the legal estate by an actual deceasant without collusion with the trustee will not be bound by the trust. Therefore, if I oust A, who is a trustee for B, and a claim is not made due him, A will be barred, and by the City Key Trust with him, although I had no notice of the trust," unquote. And the same thing may be referred from the terms of the section of the late Limited Act relating to express trusts. Chapter 13. General properties of the office of trustee. From the estate of the trustee we pass on to consideration in his office, and upon his subject we shall, in the first place, investigate the general properties of the office as first. A trustee having once accepted the trust cannot afterwards renounce it. Secondly, he cannot delegate it. Thirdly, in the case of co-trustees, the office must be exercised by all the trustees jointly. Fourthly, on the death of one trustee, there is survivorship, that is, the trust will pass to the survivors or survivor. Fifthly, one trustee shall not be liable for the acts of his co-trustee. Sixthly, a trustee shall derive no personal benefit from the trusteeship. Going back over first, a trustee who has accepted a trust cannot afterwards renounce. Number one, trustee cannot renounce after acceptance. As a rule, without an exception, that a person who has once undertaken the office, either by actual or constructive acceptance, cannot discharge himself from liability by any subsequent renunciation. The only mode by which he can obtain a release is either under the sanction of the Court of Equity or by virtue of a special power in the instrument creating the trust, or of his statutory power, or with the consent of all the parties interested in the estate and being sui juris. Next section, executor cannot renounce after he has acted. Thus, where A was named executor and acted in behalf of some particular legatees, but disclaimed the intention of the interfering generally and then renounced, and B, obtained letters of administration cum testimono annexo, and possessed himself of assets and died insolvent, it was held that A, having acted, could not afterwards discharge himself and was responsible for the devousing committed by B. 2. Morecraft versus Dowding. Though a trustee may have given a bond for due execution of the trust, and the City Key Trust may have recovered upon the bond and been paid the money, yet if the City Key Trust afterwards takes proceedings to compel a conveyance of the trust estate, the trustee cannot devise himself of his fiduciary character by pleading that the penalty of the bond was instated damage for the breach of the trust, and that on payment of the penalty of the trustee should be released. A conveyance, however, will not be decreed without an allowance to the trustee of the penalty recovered upon the bond with the interest said at the usual rate. Secondly, the office of a trustee being one of personal confidence cannot be delegated. Number 1, trustee cannot delegate the office. Trustee, said Lord Langsdale, who take on themselves the management of property for the benefit of others have no right to shift their duty on other persons, and if they do so, they remain subject to responsibility towards their City Key Trust for whom they have undertaken the duty, unquote. If a trustee therefore confides the application of the trust funds to the care of another, whether a stranger or his own attorney or solicitor, or even a co-trustee or co-executor, he will be personally responsible for any loss that may result. But the trustee were held not to be responsible where they drew a check and delivered it to the co-trustee, but crossed with the names of the bankers for whom the money was meant to be paid and to whom it was payable in the due execution of the trust, and the co-trustees, as the court assumed, erased the crossing and received the money himself, for such receipt was a fund on the trustees and not the result of any of their acts. 2. Balshan versus Scott. In the case of Balshan versus Scott is no exception to the general rule, for there is an executor had received a bill of exchange by a post from a debtor to the estate and transmitted it to the co-executors, and it was held by this proceeding that the executor was not acted in the trust, and therefore was no more answerable for the application of the money by the co-executor than any stranger could have been under similar circumstances. Number 3, Churchill versus Hobson. In Churchill versus Hobson, an executor paid £500 into the hands of a co-executor who misapplied it, and it was ruled by the court that he was not bound to make it good, but the decision was universal, considered as having turned upon the circumstances that the co-executor was a banker and had been trusted by the testator in his lifetime, besides being made his executor at his death. Lord Harcourt, in his judgment, observed, the co-executor having been the cashier for whom the testator in his life chose to entrust his money, the executor ought to have suffered for having trusted him whom the testator himself in his life trusted. Number 4, trustee may delegate by testator's direction, but trustees cannot be answerable if they merely follow the testator's direction. Thus, the testator by the will recommended his executors to employ A, who has been in the testator's own employment, as their clerk or agent. The executors gave A a power of attorney to receive debts, and A subsequently became insolvent. It was contended that the executors were answerable for the default of A, but Sir A. Hart said that if a testator pointed out an agent to be employed by the executor, and such employee received a sum of money and immediately made default, the executor would clear himself by showing that the testator designated the person and that he could not, by excuse of reasonable diligence, recover the money. 5. Trustee acting as agent. As an executor cannot be answerable for having handed over money which he had no legal right to retain. Thus, the testator appointed A, B, and C as executors and empowered one of them, A, to sell certain freehold promises and directed the proceeds to the sale to be applied and disposed of in the same manner as the personal estate. A employed B as his agent to make the sale, who, having disposed of the property, paid the proceeds by A, by whom the money was misapplied. It was held that B was not answerable for this, the money having come to his hands, not in the character of executor, but of agent. 6. Delegation permitted where there is a moral necessity for it. the trustees and executors may justify their administration of the trust fund by the instrumentality of others, and there exists a moral necessity for it. There are, said Lord Hardwicke, two sorts of necessities. First, the legal necessities, and secondly, moral necessity. As to the first, distinction prevails where two executors join in giving discharge for money, and one of them only receives it because both are answerable for it. Because there is no necessity of both to join in the discharge, the receipt of either being sufficient. But if a trustee joined in giving a discharge and only one receives, the other is not answerable because his joining in the discharge was necessary. Moral necessity is from the usage of mankind. If the trustee acts as prudently for the trust as he would have done for himself, and according to the usage of business, if a trustee appoints rents to be paid to a banker at the time of the credit, but who afterwards breaks, the trustee is not answerable. So in the employment of stewards and agents, of none of these cases are on account necessity, but because the person acted in the usual method of business. And Lord Loughborough, in very similar terms, observed, if the business was transacted in the ordinary manner, unless there be some circumstances to create suspicion, surely the allowance is fair. Necessity, said Lord Cottingham, which includes the regular course of business, will exonerate. And Lord Redesdale, in the same spirit, observed, an executor living in London is to pay debts in Suffolk and remit monies to co-executors to pay those debts. He is considered to do this of necessity. He could not transact business without trusting someone, and it will be impossible for him to discharge his duty if he is made responsible where remitted money to a person to whom he would of himself have given credit and would in his own business have remitted money in the same way. Ex parte Griffin. In conformity to these principles, where A and B were co-assignees of a bankrupt, and A signed a dividend check upon the bankers in favor of the creditors and delivered them to B, who undertook to affix his signature and delivered them to the creditors, and B accordingly signed the checks and placed them in his desk. Once they were stolen and presented at a bank and paid, and on the application of the court to make A answerable, Sir J. Leach was of the opinion that the delivery of the checks by A to B as his co-signees was an act done of necessity in the course of business, and that he was not responsible for the subsequent loss of the checks. Next one, respite. So where a trustee employed a broker in the ordinary course of business to invest trust funds in proper securities authorized by the trust, on a receipt of the brought note handed over a check for the purchase money to the broker who misappropriated it, the trustee was not liable to make good of the loss, but the trustee negotiating with the municipal corporation through a broker for the direct loan to them would not be justified in handing over the money to the broker for payment to the corporation, for there would be no moral necessity or sufficient practical reason for the usage of mankind or otherwise to justify such a course. 7. Ex parte Townsend. But where the assignees of a bankrupt employed an attorney to recover debts due to the estate, and the attorney brought actions to recover the money and abscond, Sir A. Hart held them accountable on the ground that there was no necessity for permitting the attorney to receive 1 shilling of money recovered further than his cost, and it laid down that if the attorney received the money one day and become insolvent the next, the assignee would be liable. And his lordship said that the same point had been decided in an unreported case before Lord Eldon. Trustees undoubtedly must not let the money lie in the hands of the attorney, but that they must not suffer it to pass through his hands in the ordinary course of business, in the recovery of a debt by action was beyond any previous decision, unless, as suggested, it had been so ruled by Lord Eldon. However, as where the authority of Sir A. Hart that the plaintiff's attorney is in action cannot videture off officii, sign a discharge, and that if the plaintiffs empower him to receive the amount recovered, they are answerable for his receipts as to the act of the agent improperly employed to sign such receipt. 8. Trustee is not required security for his agent. A trustee or executor is not called upon to take any security from the agent, nor for to do that upon any occasion would tend greatly to hindrance of the business. If a trustee employs an agent under circumstances which justify the employment and the loss arises from the insolvency of the agent, the onus on the person seeking to make the trustee liable for the loss and to show that it was attributable to the default of the trustee. Number 9, how trust money is to be transmitted. Where trust money is to be transmitted to a distance, the trustee may do so, or may do it most conveniently and securely through the medium of a responsible bank, and he may take bills drawn by a person of undoubted credit and payable at the place whether the money is to be sent. 10. Payment into bank must be to the account of the trust, but the money must be paid into account of the trust estate, and the bills must be taken in favor of the trustee in the character, and if he neglect these precautions, then if the bank break and the bills be dishonored, the trustee will be liable for the loss to the City Key Trust. 11. Rule at law as to liability to executors. The rule formerly applied to executors in a court law seems to have somewhat different from that established in the courts of equity. An executor, once becomes responsible for actual receipt of any part of the assets, could not at law have been found his discharge in respect thereof and against a creditor, either by a plea of reasonable confidence disappointed or to a loss not occasioned by a negligence or default, as if an executor transmitted a sum to his executors under circumstances that in equity would have justified the confidence. A court of law would still have held him responsible for any misapplication by the co-executor and could not allow him to plead penal pleni administrative. But now that the rule of equity prevailed over the rules of common law, where they conflict and distinction has disappeared. 12. Delegation of discretionary trust. If the trust be of discretionary character, not only is the trustee answerable to all the mischievous consequences of the delegation, but the exercise of the discretion by the substitute will be actually void. Thus, an avowson was vested with 25 of the principal inhabitants of the parish upon trust to elect and present a proper preacher, and some of the trustees having disputed proxies to vote in the election, Lord Hardwick held that as the election had been conducted in this manner, it could not be supported. Where trustees may, however, inquire as what are the wishes and opinions of others, especially of those who are interested, before finally determining what in the exercise of their own discretion they think expedient, they will not be held to act against their own judgment, but they should in the end disregard objections to what they had previously given weight. 13. Not permitted, though to a co-trustee. A discretionary trust can no more be delegated to a co-executor or co-trustee than a stranger. Thus, where a sum of money was given to 3 executors upon trust to distribute in charity at their discretion, and the executors assumed each the independent control of 1/3, Lord Hardwick said, I am in the opinion of executors could not divide the charity into 3 parts, and each executor nominated a third person, a third absolutely, because the determination of the property of every object was left to the testator to the direction of all the executors. 14. Transfer of trust estate does not transfer the power. Of course, if a trustee convey the estate and a mere transfer of the estate does not have the effect to carry with it the trust or power to the grantee, and if so a trustee divides the estate, the divisee cannot administer the discretionary trust unless the original settlement contemplated such an event, and by divesting the powers in the trustee, he assigns and annexed the powers to the estate in the hands of the divisee. 15. Delegation distinguished from appointment of a proxy. It must be noticed that the appointment of an attorney or a proxy is not, in all cases, a delegation of the trust. When the trustee has resolved in his own mind that what manner to the exercise his discretion, he cannot be said to delegate any part of the confidence if he merely executed the deed by attorney or signify his will by proxy. Thus, in a case before cited, where the trust was to elect and present a proper clerk to benefit Lord Hardwick had no doubt so far as related to the mere act of presentation. The trustees, having themselves fixed upon the object, might have signed the presentation by proxy. A trustee who had a legal estate might make an attorney do legal acts. 16, appointment of surveyor. Trustees who are exercising the statutory power of sale conferred by the Lands Clause Consolidation Act of 1845 cannot appoint one of themselves to be a surveyor to value the land under the 9th section of the Act, for the appointment of the surveyor under the section is intended to check on the actions of the trustee. Thirdly, in the case of co-trustees and office, it is a joint one. Number 1, trust a joint office. Where the administration of a trust is vested in co-trustees, they all form as it were one collective trustee, and therefore must be execute the duties of the office in their joint capacity. It is not uncommon to hear one of several trustees spoken of as the acting third trustee several trustees spoken as the acting trustee, but the court knows no such distinction. All who accept the office are, in the eyes of the law, acting trustees. If anyone refuses to be incapable to join, it is not competent for the others to proceed without him, but the administration of the trust must be in a case devolve upon the court. However, the act of one trustee done with the sanction and approval of a co-trustee may be regarded as an act of both, but such sanction or approval must be strictly proved. 2, notice of renewal. Notice of an intention to exercise a right of renewal of a lease or of property vested in several trustees is good if served upon one only of the trustees. Number 3, receipts. A receipt for money must, in the absence of a receipt clause specially worded, receive the joint authentication of the whole body of trustees and not of the majority merely, or it will not be valid. And therefore, where the trustees are numerous, it is a common in orders of the court to insert a special direction that the monies may be paid to any or more of them, two or more of them, Number 4, all the trustees must prove. Again, if a debtor to the trust becomes bankrupt, all the trustees should join in the proof, but under particular circumstances, the court will make an order for some of the trustees to prove, but even then the court has occasionally inserted a direction that the dividends shall be payable to all the trustees. 5, acknowledgement of debt by one trustee. If a mortgage be made to two trustees so described in the statutory period elapse, an interim acknowledgement by one of the trustees will not prevent the operation of the statute of limitation and bar of redemption. 6, in public trusts, the majority of the trustees may bind the next. Where there are several trustees, the trust is of a public character, and the act of a majority is held to be the act of the whole number, as where were seven trustees, and they meet for the purpose of electing a schoolmaster, and at the meeting 5 of the trustees concurred in the appointment, but 2 dissented. The act of majority was considered to bind the majority, but of course the act of the majority does not bind the minority, so far as the act is bound beyond this proper sphere of the duty of the trustees. And when a special power is given to trustees, it cannot be exercised by the majority only, but all must join. Now by 32 and 33 Victoria, Section 110, subsection 12, it is enacted that a majority of charity trustees present at a meeting duly constituted and voting shall have and demand to have always had the same power of disposition over the charity property, and if it were the acts of the whole body, and by the 13th section of the majority of the charity trustees may, and with the sanction of the charity commissioners, sue as if they were the sole trustees. 7, trustees of charities. Where a numerous body are appointed trustees by the court, as in cases of charity, the court sometimes, for greater convenience, annexes the order direction, and part of them shall form a quorum. Number 8, dividends and rents. If the stock be standing in the names of several co-trustees, then as they are joint tenants and the bank does not recognize the trust, any one of them may receive the dividends. though all must join in the sale of the corpus, and the trust itself has occasionally directed the dividends of stock standing under its control to be paid to one of the several trustees. And in the case of the bank annuities standing to the credit of trustees of a charity, the court to prevent the necessity of recurring applications on charges of trustees made an order for payment of the dividends to the trustee or any two of them, or to the other trustees for the time being or any two of them. And another case for the payment of the trustee for the time being or one of them. And there are co-trustees of lands, and any one of them may receive the rents, though all must concur in the conveyance. But if there be two trustees and one of them receives the rents and misapplies them, and the other trustee has no notice of this, it is the duty of each other trustee to serve a notice on the tenants not to pay the rents to the defaulting trustee alone. And if he admits to do this or take the necessary steps to ensuring the safety of the rents as against the defaulting trustees, he will himself become liable. Number 9, co-trustees should not serve in legal proceedings. As co-trustees or joint body, the courts require them, unless under special circumstances, to defend a suit jointly, and if they serve, the extra cost thereby occasioned must be borne by the defaulting party. It is convenient that this rule, so strictly observed in the court, must not be lost sight of in transactions out of court, and that co-trustees are bound, unless they can show good reason to the contrary, to act by the same solicitor and the same counsel. It would be a strange anomaly if 4 trustees were allowed only one solicitor, one counselor in court, and 4 separate solicitors and 4 separate counsels out of court. Every trust must be prepared to act in harmony with his co-trustees, or he should not accept the office. It may be said that each trustee is responsible for the due administration of the trust. He ought to be at liberty to employ a professional advisor of his own choosing, but this argument would be a fortiori applied to so important a matter as the defense of a suit, and yet the court pays no attention to it. Fourthly, on the death of one of the trustees, the joint office survives. Number 1, survivorship of the trust. It is a well-known maxim that a bare authority committed to several persons is determined by the death of any one, but if coupled with the interest, it passes to the survivors. Thus, the committees of the lunatic's estate are regarded in the light of the mere bailiffs without a spark of interest, and if one of them die, the office is immediately extinguished, and where under an order for maintenance, 2 trustees were directed to pay the income of the trust fund to the mother of an infant for the maintenance of the infant during her minority, and one of the trustee dies and the survivor continued the payments, it was held by late M.R. that the trust for the maintenance arose only under the order and did not survive. But this view was not acquiesced by the Court of Appeal, where the decision was drawn between the power and the positive direction involving no discretion, but an executorship or administratorship survives. For if, said Lord Talbot, a joint estate at law will survive, why should not the joint administration when they both have joint estate in it? So if a testamentary guardianship vests in the survivors, for as guardians may bring action to avoid their own names, may grant leases during the minority of the ward, and dismiss copyholds even in reversions as lords pro tempore, it is evident that they have an interest. It follows as co-trustees have an authority coupled with an estate or interest, the office also must be impressed with the quality of the survivorship, as if the land be vested in 2 trustees upon trust to sell, one of them dies and the other may sell, and if it avows and be conveyed in trust upon trust, conveyed to trustees upon trust to present a proper clerk, the survivors or survivor may present. Otherwise, indeed, the more precaution a person took to increasing the number of the trustees, the greater would be the chance of the abrupt determination for the trust by the death of any one, even where the trust was to raise a sum of £2,000 out of the testator's estate by sale or otherwise at the discretion of the trustees, who should invest the same in the names of the said trustees upon trust, and one of them two trustees died and the survivor sold, Vice Chancellor Wood decided that survivor could make a good title. I find, he said, a clear estate in the vendor and a clear duty to perform. It is said that the sale is a breach of trust because the co-trustee is dead. If it were to lay down such a rule, it would come to this, that wherever an estate was vested in two or more trustees to raise a sum by sale or mortgage, you must come to the court on death of one of the trustees. 2. Survives though there be a power of appointment of new trustees. The survivorship of a trust will not be defeated because the settlement contains a power of restoring the original number of trustees by new appointments, unless there be something in the instrument that specially manifests such an intention, even of an act of Parliament which declared in very strong terms that the survivors should, and they were thereby required to appoint new trustees. The court said the proviso was analogous to the common one in settlements and expressed an opinion for the discretion was upon another point, that the clause is not operative but merely directory character. 5thly, trustee not liable for his co-trustee. One trustee shall not be liable for the acts or defaults of his co-trustee. Number 1, Townley versus Sherborne. This canon appears to have been first established by the case of Townley versus Sherborne in the reign of Charles I. A, B, C, and D were trustees for some leasehold premises. A and B collected the rents during the first year and a half and signed a quittance, but from the period the rents were uniformly received by an assigned of C. The liability of A and B during the first year and a half was undisputed, but the question was raised whether or not also chargeable with the rents which had accrued subsequently but had never come into the hands. The Lord Keeper, Coventry, says the reporter, considered the case to be of great consequence, and though not to determine the same suddenly, but to advise thereof, and desired the Lords and Judges' assistance to take the same into their serious consideration, whereby some course might be settled that parties' trustees might not be too much punished, lest it should be disheartened men to take any trust, and it would be inconvenient that on one side, nor that too much liberty could be given to the parties' trustees, lest they should be embodied and break the trust imposed on them, so it would be much prejudicial on the other side. And the Lord Keeper and the Lords and the Judges' assistants afterwards conferring together, and upon mature deliberation receiving the case to be of great importance, his Lordship was pleased to call unto him also Mr. Justice Crook, Mr. Justice Bartley, and Mr. Justice Crawley for their assistance also in the same, and appointed presidents to be looked over as well as the Court of Chancery as in other courts, if they could be found teaching the point in question. Upon several precedents were produced before them, some in the Court of Chancery and some in the Court of Wards, where parties' trustees were chargeable only according to the several and respective recipients, and not one to answer for the other, but non-precedent to the contrary was produced to them. Whereupon his Lordship, after long and mature deliberation on the case, and serious advice with all the said judges, did this day open court declare the resolution of his Lordship, and said judges that where lands or leases were conveyed to two or more upon trust, and one of them receives all or part of the profits, and after dieth or decayed in the estate, his co-trustee shall not be charged or compelled in the Court of Chancery to answer for the receipts of him so dying or decayed, unless some practice, fraud, or evil dealing appear to have been in them to prejudice the trust, for they being at law joint tenants or tenants in common, every one by law may receive either all or as much of the profits as he can come by. It is no breach of trust to permit one of the trustees to receive all of the most part of the profits, and falling out many times that some of the trustees live far from the lands and are put in trust out of their other respects than to be troubled with the receipt of the profits. But his Lordship and said judges did resolve that if upon the proofs or circumstances the court should be satisfied that there had been any dolus malice or any evil practice, fraud, or ill intent to him, that permitted his companion to receive the whole profits, he should be charged though he received nothing. Number 2, trustee not liable for joining pro forma in receipts. Co-trustees, it was determined in Townley versus Sherborne, were formerly considered responsible for monies if they joined in signing the receipt for it, but in latter times the rules have been established that the trustee who joins in a receipt for conformity but without receiving shall not be answerable for misapplication of the trustee who receives. Where the administration of the trust is vested in co-trustees, the receipt of the money paid to the account of the trust must be authenticated by the signature of all trustees in their joint capacity, and it would be tyranny to punish the trustees for an act which the very nature of the office will not permit him to decline. Number 3, but he must prove that he did not actually receive. But it lies upon the trustee who joins in the receipt to show that the money acknowledged to have been received by all was in fact received by the others or others, and that he himself jointly only for conformity. In the absence of all evidence, the effect of a joint receipt is to charge each of the trustees in solido, and if the mortgage be devised to the third trustees and the mortgagor with his witness meets them to pay it off, and the money is paid on the table, and the mortgagor, having obtained a reconveyance and a receipt for his money, withdraws, each of the trustees in this case will be answerable for the whole. A joint receipt at law is conclusive evidence that the monies came into the hands of both, but the Court of Equity, which rejects estoppels and pursues truth, will decree according to the justice and verity of the facts. Where, said Lord Cowper, it cannot be distinguished, however, which was received by one trustee and how much by the other. It is like throwing corn or money into another man's heap, and when there is no reason that he made this difficulty should have the whole, or the contrary, because it cannot be distinguished, he shall have no part. 4, trustee joining in a receipt must not permit the money to lie in the hands of the co-trustee. And though the trustee joining in a receipt be safe in merely permitting his co-trustee to receive in the first instance, he will not be justified by allowing the money to remain in the hands for a longer period than the circumstances in the case reasonably requires. And it is the duty of the trustee not to rely on the mere statements by his co-trustee that the money has been duly invested, but to ascertain that such is the fact. The two trustees authorize the co-trustee to remove from their banker's box containing active Spanish stock, and for the purpose of converting it into deferred Spanish stock, and the co-trustee, after the conversion, returned the box with only part of the converted stock in it, and the trustees who relied on the assurance of the co-trustees to the solicitor that all was right and did not assert the fact were held liable for the deferred stock which had been misappropriated. Number 5, Walker versus Simmons. Walker versus Simmons involved an unusual particularity of circumstances, but as Lord Eldon described in his case of great importance to the trustee in general, it may be useful to present a summary of it as so far as it bears upon the present subject. In a sum of money secured by mortgage, it has been assigned to Donathorne, Griffith, and Simmons upon certain trust. On the 12th of January, 1791, the mortgage was paid off and the estate reconveyed, and a joint receipt signed, and the money, with the approbation of the co-trustees, was put into the hands of Donathorne. The money was shortly thereafter invested by Donathorne and the sanction of his co-trustees in bills or notes of the East India Company, payable at the end of 2 years. In 1793, the bills were paid off by the company and the money received by Donathorne. Intelligence to that effect having been transmitted to the co-trustees, Simmons in the same year wrote to Donathorne requesting him to invest in the public funds in the joint names of the trustees. Donathorne begged that the money might be remained in his hands and proposed to secure a repayment of it by a mortgage from himself and his son of their settled estates in Cornwall, and until the mortgage could be repaid, to secure it by his joint bond. And the co-trustees, conceiving the security to be ample, expressed their consent, and the joint bond was accordingly executed. Donathorne, having not sent the mortgage as he promised, Simmons made several applications to him upon the subject, earnestly desiring him either to invest the money in the funds or to give them landed security. In September 1796, Donathorne died insolvent and without having executed the mortgage. Sir W. Grant observed, the money in 1791 was paid without any act of the trustees. They were obligated to receive it so far as they were blameless. It came to Donathorne's hand, and that the trustees were not blamed in letting it come to his hands, but they might have afterwards made themselves responsible by merely not doing what was incumbent on them. By permitting the money to remain a considerable time in the hands of the co-trustees, they might, without any positive act on their part, have made themselves liable. What will depend on the degree of the extent of their laches in suffering the money to remain in the hands of Donathorne. The trustees being authorized to put the money out on mortgage, it would be rather hard to say that they were guilty of laches by giving Donathorne a little time to find a mortgage, taking his bond in the meantime. What passed in the interval between the death of Donathorne does not appear, but if it was necessary to decide the point, an inquiry before the master must be directed. Sir W. Grant dismissed the bill, which was to set aside as having been fraudulently obtained, a compromise for the alleged breach of trust, but did so on the grounds foreign to the subject under decision. Lord Eldon, however, from whom the case was brought upon appeal, reversed Sir W. Grant's decree and directed an inquiry to the master as the conduct of the trustees before January 1791, when the mortgage was paid off, and to 1796, the time of Donathorne's death. Then it appeared that by the master's report, made in pursuance of the order, that the money had been invested by Donathorne soon after it had been received it, and the East India bills payable to himself, that the money due on the bills had been discharged in 1793, and the money paid to Donathorne, that the co-trustees had made no inquiry about the trust fund from January 1791 till May 1795, which was the time when Simmons wrote the letter and made the application already stated. On the hearing of the cause upon further directions, Lord Eldon said, the cause comes back with a report stating a clear breach of the trust and leaving the trust fund in a situation represented from 1791 to 1793 and from 1793 to 1795. The money was laid out in 1791 with the consent of the trustees on India bills payable to Donathorne and payable breach of trust by placing the fund under his control, secured by little more than a promissory note payable to himself. And it was profitable that in 1793 Donathorne would be paid the money due on the bills and would be lodged in his hands. And although the court will proceed as favorably as it can to trustees who had laid out the money on security from which they cannot with activity recover it, yet no judge can say they are not guilty of breach of trust. If they suffered it to lie out on the security during so long a time, the trustees were guilty of a breach of trust in permitting the money to remain on bills payable to Donathorne alone, and the leaving the state of the funds unascertained for 5 years. I agree with the Master of the Rolls that inquiry might, on the principles of this court, have discharged the trustees in given circumstances for the breach of trust, if without provisions participated. They, in June 1795, had found that being themselves implicated in no breach of trust, they had a co-trustee who had been guilty of a shameful violation of his duty and immediately exerted themselves to obtain from him a mortgage, which was their object at the time, and used their utmost efforts instead of filing a bill in this court, which perhaps might have destroyed his means of giving security. I should have hesitated long before I charged them. If inquiry had satisfied me for the simple contract debt due them, they might take a bond and a mortgage instead of instituting a suit, with the rational hope that by means of the bond and the mortgage they should obtain payment from their co-trustee. The result of this lordship's judgment was that under the circumstances disclosed by the master's report, the trustees were to be held responsible for the loss of the money. Well, that was quite a case. Number 6, executors answerable for joining in receipts pro forma. Co-executors, also like co-trustees, are generally answerable for each owns acts only and not for the acts of any co-executor. But in respect of receipts, in the case of co-executors, is materially different from the co-trustees. An executor has independently of his co-executor a full and absolute control over the personal assets of the testator. If the executor joint with no co-executor in receipt, he does a wanton and unnecessary act. He interferes with the nature of the office lays upon him no such obligation, and therefore it was ruled very early established that if an executor joined in receipts, they should be answerable, each in solido, for the amount of the money received. 7. Wesley versus Clark. In Wesley versus Clark, Lord Nottington expressed an opinion that aimed at breaking down the rule, and by the decision of that case, he succeeded in establishing a qualification of it. Thompson, one of the 3 co-executors, had called in a sum of money secured by a mortgage for the term of years, and the receipt of the amount, and afterwards, by the same day, sent round his clerk to co-executors with a particular request that they should execute an assignment and sign the receipt, which they accordingly did. Thompson afterwards became bankrupt, and the money was lost, and thereupon a bill was filed to charge the co-executors. Lord Nottington said the rule that executors joining in the receipt are liable, or all liable amounts to no more than this, that the joint receipt given by the executors is a stranger proof than they actually joined in the receipt, because generally they had no occasion to join for conformity. But if it appeared plainly on that one executor only received and the discharge of the estate indebted and assigned the security, and the others joined afterwards without any reason and without being in any capacity to control the act of the co-executor either before or after the act was done, what grounds has any court in conscience to charge him? The only act that affected the assets was the first that discharged the debt and, according to the sense of the bar, transferred the legal estate to the lands, then that the co-executors are not to answer for, and secondly is nugatory. His lordship was therefore in the opinion that the co-executors were not liable for the misapplication by the co-executors. Next, executors joining pro forma not answerable where the joining was nugatory act. The doctrine propounded in this case is that the joint receipt to co-executors is merely a stronger proof of the actual receipt that the instance of co-trustees, and that the executor as well as the trustee may rebut the presumption by positive evidence, has since been repeatedly controverted. The simple point determined is that an executor who signs shall not be answerable when the act of signatory is nugatory may be considered as now settled. Lord Thurlow, indeed, is reported to have questioned the decisions on Wesley versus Clark, but Lord Alverley said he must enter a dissent against the rule that executors joining to a receipt were both liable, for he did not hold that the executors could not in any case be discharged from a receipt given for conformity. He did not find fault for the instance, which the case of Wesley versus Clark, and he said he perfectly concurred with the decision of that case, and the joining of any receipt, though not perhaps absolutely necessary, he would not consider it conclusive. Lord Eldon, in the event allusion to the case of Wesley versus Clark, admitted that the rule had been pared down, at the same time expressing his opinion that the notion upon which the latter case had proceeded, viz. That the old rule had a tendency to discourage executors from acting, and it was very ill-founded. The plain general rule, he thought, once laid down, was easily understood and might be generally known, was much more inviting to executors than a rule referring anything to the particular circumstances. Next, present doctrine on the subject. The latter doctrine of the court was thus enunciated by Lord Eldon: though one executor as joined in a receipt, yet whether he is liable shall depend upon his acting. The former was a simple rule that the joining should be considered as acting, and now joining alone does not impose responsibility. In another case, he observed that the old rule had been broken down, leaving every case to be determined by its own circumstances. Lord Resdale laid down the rule thus: The distinction with respect to mere signing appears to be this, that if a receipt be drawn for the purpose of form and then signing will not charge the person not receiving, that if it be given under circumstances reporting that the money, though not actually received by both executors, was under the control of both, such receipt shall charge, and the true question in these cases seems to have been whether the money was under the control of both executors. If it was considered by the person paying the money, then the joining and the receipt of the person who did not actually receive amounted to a direction to pay his co-executors, for it could have no other meaning. He became responsible for the money, just as if it had actually received it. In another case, he said, where two executors joined in receipt to a debtor, though the receipt of one had been discharged to the debtor, yet they joining in the discharge, the debtor has taken to have paid them both, is requiring the discharge of the executor who has not received the money amounts to saying, I make this payment to you both, and not to him only who actually receives the money. Number 8, Churchill versus Hobson. In Churchill versus Hobson, Lord Harcourt took a distinction between creditors and legatees, that in the case of creditors who were entitled to the utmost benefit of the law, the joining of the executors in the receipt might make each liable for the whole, but where the legatees were concerned, who had no remedy for their demand except in equity, it also altogether inequitable that one executor should answer for the receipt of the other. This doctrine, thus committed upon Lord Nottingham, at law, he said, a joint receipt is conclusive evidence that the money came to them both and not to be contradicted, but a court of equity, which rejects estoppel and pursues truth, will decree according to the justice and veridity of the fact, and it said that Lord Harcourt, that the distinction between the receipt of this kind as to a legatee and a creditor seems to have this meaning, that a creditor may at law charge both executors on a joint receipt, but that the court of equity, where alone legacies are received, such receipt shall not be conclusive, but the court will see who actually received and charge the person accordingly. The distinction taken by Harcourt has been subsequent authorities been clearly overruled. Okay, looks like that might be a good place to stop right there. We'll stop on page 374. We'll pick up on executor may be answerable to creditors when not to legatees.
All right. Well, let's open up to questions, folks. If you got a question, hit *8 on your phone. We'll go ahead and unmute you when you pop up here and give an opportunity to ask Christian a question. First call is from East Virginia. You've been unmuted. Go ahead with your question.
Yeah, I don't really have a question, but I've got a comment that I would like to make. And I was reading today in some of my email, and I get email from Merlin on your remedies in the law, and they said in there that use, USE, literally means benefit, and the term use is an indication of a trust. It says you go to jail not from a breach of contract, but of a breach of trust. Now, I find that rather interesting, that they are aware of what's going on in that realm, but they're not studying trust. Don't you find that interesting?
I think it's because they don't know the trust law, because trust law under Section 161 of Book 90 of Corpus Juris Secundum states plainly that says if you have a trust, you must treat it as a trust.
Yeah, that's true.
That's with the understanding that they lack.
Yeah. Well, they're certainly close to the truth there, and I found that rather interesting because I wanted to bring that out tonight to just as a confirmation that I know now for sure, not just because of what we're saying, but from what other people are now saying outside of the realm of studying trust, that we are going in the right direction here. So I just wanted to kind of bring that out tonight.
They'd really started out studying trust. If they've studied it long enough, they would have come to that conclusion.
Well, yeah, if they would stay studying trust, they would, yeah. But to come this close and then not pursue it, I find that rather obtuse, really.
Yeah, it's very strange. I know it's very some of the fine minds that we have out there, but yet so close, but yet no cigar.
Yeah, no cigar. Okay. Couldn't have said it better myself, Christian. Okay, well, I just thought I would just throw that in for whatever it was worth tonight.
Thanks, Floyd. Appreciate it.
Okay.
Thanks, Floyd.
You bet. You're welcome.
Folks, if you have a question for Christian, go ahead and hit star 8 on your phone. And we'll give you an opportunity to ask Christian a question. Or a comment.
Well, let's point a question to them. Do they understand what NTT is all about in its basic form? Can anybody give a simple definition of NTT?
Simple definition of NTT. Well, I don't have anybody that's hitting star 8 yet, but while we're waiting, maybe I can take a stab at it. NTT is making payments under trust, which is merging titles and extinguishing debt.
Yep, that's it. You've been taking notes.
Yes, I have. Anybody else want to comment on that? Star 8 to make a comment, folks. You'll pop up my screen here, and I can unmute you. Star 8. Well, Christian, we might have a short night tonight.
Oh, wow. I guess we need somebody to break the ice somehow here.
It's like Dominic has a question. He's not able to jump in. Let me unmute you now. Dom, you've been unmuted.
Hello.
Hi, Dominic.
Hey, Christian. How you doing? Hey, Matt.
Okay.
Hey, Dom.
Hey, how you doing? Christian, a question, hypothetical, of course. In the case of somebody writing off to a court and putting in a defense in light of previously submitting, we'll say, trust documents, what would a person do if the court sent back the defense and told them to readjust the counterclaim?
Okay, they're telling you something that you're insufficient in some way, and they're probably giving you a second chance before they dismissed it, and they're probably doing you a great justice for that.
Yeah, that seems to be the impression that we're getting. The adjustments, I'm trying not to get too specific about this now, obviously, but the adjustments seem to be that the party making the claim would be the name of a specific lender, and of course the counterclaim would be mentioning a specific individual within that institution. And where the court replies back and suggests the removal of this specific individual as he is not a party to the case, how would one include that particular individual, since all private communications are made to him? How would one include him in the body of a counterclaim, would he still mention his name without actually putting him as plaintiff?
This would be a party that has an interest?
This would be a situation where between a lender and an individual who is trying to extinguish the debt on the private side using NTT, and it would be between him and a lender, and obviously the lender has taken action against this particular individual, and this individual has responded back with a defence stating that a payment has been instructed and instructions has been given to a specific individual to carry out this payment alongside with a counterclaim also. But the thing is, the court has now instructed this particular individual that that the parties on any defence and counterclaim can only be the defendant and the plaintiff. It cannot be anybody else. So a CFO or CEO would be an agent for that particular institution and not to be named in the case. How would one get around that? Well, not get around it, but how would one construct a counterclaim or defence in light of that?
So they're saying that the trustee is not
party to the case.
Party to the case.
On the public side, yeah.
Because it should be the organization or the corporation.
Correct. So they sent me. So the court would have sent back. Excuse me. The court would have sent back documentation instructing to change the paperwork around and put the institution as a plaintiff and obviously this particular individual as defendant. Without mentioning, no other parties are to be mentioned in the heading of these documents. So I'm just trying to figure out a way. How would one say that in a defence, for example, I such and such, whatever the case may be, have authorised payment to settle, discharge, and extinguish any outstanding debts relating to such and such account, without mentioning, without actually. I hope I'm not confusing this now. Because I can't name this individual on in this particular defence.
I think what they're saying is we can't see the real man on the public side, so therefore he can't be named on the public side.
Yeah.
So
okay.
Maybe you need to restate it as the man as the fiction. That might be what they're saying.
The man is a fiction. Yeah, because the case would have been the institution. The institution would have taken action against this individual.
Yeah, because equity is in personam, acting upon the person, and that's on the private, so that's affecting the real man.
Yeah.
Where on the other side, on the public side, that's in rem. And that affects the corporation.
Yes. Mm-hmm.
So if you're going into equity, that would concern the real man, but yet on the public side, they can't see the real man, so they need to address the fiction.
Yeah. That would seem to be what's happening here, yeah.
So why don't you make it all out in a cap's name for the man, which would be the fiction name, and he would be CEO for the corporation.
Yeah. No, the court have already been contacted regarding this matter, and the court has been very, very specific in who the plaintiff is to be in this case and who the defendant is to be. And the plaintiff cannot be any particular individual. It has to be the person that initiated the claim, or it has to be the corporation that initiated the claim. It cannot be anybody else. So I was told this, like. So rather than putting that, I was thinking of possibly going along with that, but mentioning in the body of the counterclaim this particular individual acting on behalf of this particular lender has been given instructions, yada yada, you know. Because if I put the individual higher caps on, do I run the risk of the paperwork being resent back to me again? Do you know?
Well, we have over here, we have something called, the court is supposed to do a ruling on conclusions and facts entered into evidence.
Mm-hmm.
And if they send you back something, you have the right then to ask them for details. Why did you refuse it? Or give me some kind of thing, you know, other than just saying, you know. But I assume that you, by what you said, they may have told you some kind of instructions, right?
Yeah, correct. Yes.
So if you were unclear, you might want to write back to them and say, you know, could you clarify a certain respect or something? But
yeah.
what it looks like is that they're not saying that you can't come out with a case, but they can only see the fictions on the public side, and you have to at least give them what they can see on the public side to get you into the equity part, so you can come back and treat that as the real man then.
Yeah, yeah. And it's really interesting, because when the court was contacted, the person in charge who receives all these documents was more than adequate to discuss this, and was actually full of suggestions and very supporting, actually, and understanding.
Sounds like equity.
Yeah. I was kind of shocked to hear how they were like that, but the suggestion came up then from their end, of course, not being legal advice on their end, was to if there was any specific claim against this particular individual, being the CEO, that a separate action should be taken against him, with him named specifically as the defendant on it, on a separate action, on an equity bill or a separate action. So.
Okay, so they're saying to come at them with the corporation and attack the corporation first, but then come at the real man privately on his capacity for the trustee?
Correct.
Uh-huh.
And this was them telling me this, like, which I found interesting, you know.
So like a suit at law against the corporation, well, that would fit perfectly with Lewin right in the beginning, because that's what we were talking about. Because the summons was for the corporation, and now the subpoena is for the real man.
Yeah.
Two separate cases.
Yeah. Not a counterclaim, but a separate case.
Yeah, right.
Yeah. It seems to be order and procedure here again, Christian. It seems to be keeping to the rules and the forms and procedures of what the courts are looking for. And I think if you do that, you're kind of, you know, you're playing their game, so to speak. But yeah, I was a bit taken back by that, actually, when he said, you know, you can do this if he says, I don't know what your thing is. He says, but you can do this if this is the route you want to take. But in this action, you have to stick to the parties in the action specifically. It's interesting. The CEO is he's an acting agent for the institution. So I'm thinking I'm just going to go ahead and just name him in the body of the defense or of the counter. You know?
Yeah, but almost have to be, because he's a corporate fiction CEO on that corporation. He's the head of that corporation, so. Yeah.
See, somebody has to be, or some specific role has to be responsible for taking instructions or for taking payment within that institution. So that's why it would be necessary, and it would make sense to name a specific individual that these instructions have been given to settle this.
So was your captioning on your original complaint, was it just by the bank's name alone?
On their action against me, or
no, your counterclaim.
The heading on the counterclaim was it was the CEO individually.
Without the corporation?
Correct. Yeah, without the corporation.
So I think what they want to see is probably the individual with the corporation.
Okay. Okay. Yeah, that would make sense. Yeah. Yeah, that would make sense. Yeah, just change a few headings. As I said, just form and procedure again, filling out the forms correctly, giving the courts kind of what they want as such, in order for them to see what's going on. Like, yeah, because you could put the name of the corporation and you could put him in brackets, or put him and put the name of the corporation in brackets after his name.
Yeah, and use his all cap straw man name.
Yes, the higher caps. Yeah, absolutely. Yeah, I can do that, no problem. Yeah.
He used his lowercase name.
Sorry,
and
no.
Then subpoena him.
Yeah. That's on the separate action, yeah.
Yeah, so you summons the corporation first, and then you subpoena the real live man next, just like it says in Lewins.
Yeah. Yeah, I just wanted to bounce that off because I wasn't sure as I just got this today, so I said I'd act on this straight away.
Right on page 1, book, right on the first page of Lewins. The subpoena, originally the only pledge for the due execution of the trust was the faith and integrity of the trustee, but the mere feeling of the honor of providing was likely, when opposed to self-interest, an extremely precarious security. And then John Waltham, Bishop of Salisbury, who was Lord's Keeper in the reign of Richard II, originated the writ of subpoena, by which the trustee was liable to be summoned into chancery and compellable to answer upon oath the allegations of the City Key Trust. So there's your summons and your subpoena.
Yeah.
Summons for the corporation and a subpoena for the real man.
Yeah, public and private.
Mm-hmm.
Yeah, it makes sense. Yeah, it makes sense. So you could go at him with a separate action, an equity bill against a real man.
So are they saying that you could come in and do your counterclaim under the corporation, but then start a new separate action against the man?
Yes.
On him?
Yeah.
In equity?
Yes.
I wonder if a cross bill would be any way of doing that.
A cross bill.
You'd have to look into that one.
That's different to a cross action, I presume. Obviously, it is. Yeah.
I'm thinking, one of the maxims of equity is that equity is going to present or prevent a multiplicity of suits. So if you have a civil action going on one claim, and then it arises from the root of the other claim, I would say that equity would want to have a tendency to combine the two.
Yeah. Yeah. Yeah, because one is initiating the other, like.
Yeah, you'd probably have to go back and review when we talked about ancillary cases under equity.
Yeah.
But then, whatever they said out of the court, they're not just saying it because, they're trying to harm you. I think that's probably wise information.
Yeah, I think so too, actually. When I got the letter, I couldn't make sense of it. And then I said, you know what? I'm going to ring him. I'm going to ring him and have a chat with him. And I did. And no, he was just, we were just talking like you and me right now, just having a chat. And he was just telling me, this is what you need to do. This is what we accept. And if you want to go this route, you can do this. And he was saying, this is the fee for this. This is the fee for that. And
well, I would do what he says.
Yeah.
I don't think he's steering you wrong.
No, I don't think so either. Again, it's just back to forms, procedures, and structure and elements of different forms, to correct the headings and stuff like that. Yeah.
I think probably enough in there to, they could see that you were in an equity standing and they had to treat you under substantive rights rather than treat you as the fiction, and they were much more cooperative in giving you a relief.
Yeah. Like,
Otherwise, they probably would have shut you down and said, "Oh no, we reject this."
yeah, the only thing, I can read it out to you. He says, I'm in receipt of your letter. And he says, please note that the heading on your documents is incorrect. So that's, and he says, please attach the counterclaim fee, which is my own negligence because I should have sent that in and I didn't, but it's not a problem. But, so then obviously I needed to find out what documents needed correcting. And I rang him and he said, well, the headings on your counterclaim, and yeah, the heading, actually my defense was okay. It was the heading on the counterclaim was incorrect because I didn't have the name of the institution as the plaintiff. I had me as the and I had the individual, the CFO, as defendant. So he said, this needs to be corrected. He says, everything else seems to be okay, just the heading in a counterclaim. So he said, the plaintiff is not you. He says, the plaintiff is the lender, he says, and you're the defendant. This needs to be corrected, and that's all. So I said, okay.
All right, so yeah, because first should be the plaintiff, which would be the bank.
Yeah.
How they have their name in there, the bank's name.
Yeah, that's right. They have the governor and company of such, yeah.
Bank's name.
Yeah.
Okay, then you're listed as defendant.
Correct.
So when you come in with a counterclaim, you should have that exact same heading first, but then right below that, you're going to put another duplicate of that. Next line would be plaintiff, but now it's third-party plaintiff, which is you, and the line below that should be third-party defendant, which is the bank.
Ah, right. Okay. Okay. That's interesting there now.
You take exactly the way it is on their complaint, which is plaintiff and defendant, and you duplicate that right below it, and except now you flip the parties. That's a counterclaim.
All right. Okay. So I'm just reading out of my Irish Law Dictionary here, and it says, if such counterclaim raises questions between himself and the plaintiff, along with any other person, he is required to add a title setting forth the names of the defendants to such cross-action.
Yeah, so he becomes third-party plaintiff,
yeah,
which is you, and third-party defendant, which is them.
Yeah. He is required to add a title setting forth the names of the defendants. Yeah. Yeah, so that would be that, so, yep. Cool. That makes perfect sense to me now. So I have very little to change, just a couple of minor amendments, and I can send it back in again. Sounds good to me, Christian.
Okay, all right.
Thank you for your time. I appreciate it.
Okay, Dom, thanks.
Thank you.
Thanks,
Cheers.
Tom. Great to hear your voice again.
Cheers, buddy.
Okay, folks, next caller. State your name and where you call from, please. You've been unmuted.
Hello, can you hear me?
Yes. Who's this?
This is Aline. Hi, Christian.
Hi.
Hey, I just have a quick question. Last time you told me last week to call back on a Wednesday that this gentleman, Michael, might be, Mike or something, might be on the, you said he showed up. You
Mike
remember?
in Chattanooga, yes.
Do you think he's on the call right now? Oh.
Well, we'll just make an announcement. Mike in Chattanooga, if you're out there, could you come on? She's got something similar that she wanted to ask you about.
Mike, hit star 8 on your phone. That way I can see you if you're on the call tonight. Somebody jumped on. It says Jeff Joseph.
Oh.
Is this Mike?
No, I'm not Mike. I'm sorry. I apologize.
No sweat, Jeff. Just hit star 8 again. I'll meet you out. Just hit star 8 again.
I was just checking if he was there. You said to call maybe on a Wednesday.
Yeah, usually he's on Wednesday call, yeah. Mm-hmm.
Okay. Maybe we can. Okay, thank you.
You know what a Skype handle is, Christian?
I don't remember.
Chattanooga.
It might be Mike in Chattanooga, maybe. I don't know.
All right. Well, sorry, Eileen. I wished he would have been on here tonight, but it doesn't look like he's jumping on.
Okay. Thank you.
All right. Thank you.
Hopefully, try us again next week. See if he gets on next week.
Okay. Thank you. If you happen to talk to him or hear about him or something, you can let me know. And you could, your wife has my Skype address and stuff. You know.
Okay. Yeah. Right.
Thank you. Appreciate it.
All right. Next caller. You have been unmuted. Zyq, did I say that right? Hello? Go ahead. You're on the call. What's your name and where are you calling from?
This is Don from Arkansas.
Hey, Don. Welcome to the call.
Thank you. I just wanted to follow up with the conversation that we had on the 26th of July relating to a special account with a bank, local bank. Christian said to send in an order. So we sent in an order. And today we got a response. So, Christian, would you like me to read the response?
Yeah, go ahead.
Dear Mr. Smith, we represent Arvest Bank. Arvest Bank received your correspondence of July 28, 2010, consisting of documents titled Payment Request on Account from Ford Motor Company, account number, blah, blah, blah. Notary certificate of service in order to extinguish debt. Please be advised that Arvest Bank is not holding any trust assets for you, nor has Arvest Bank accepted any trust responsibilities or obligations on your behalf. Arvest Bank will not be extinguishing any debts on your behalf with Ford Motor Company or any other third party. This letter also is to advise you to cease your communications and correspondence with Arvest Bank. It is our understanding that your deposit account with Arvest Bank have been closed and that there is no reason for any communications with Dennis Smiley. Any future communications you may send to Mr. Dennis Smiley will be ignored by Arvest Bank. If you must communicate with Arvest Bank, direct all correspondence to the undersigned. Sincerely, I think I'm important.
What was that again on the end?
Oh, I'm being facetious. It's her name. And I just said, I think I'm important.
Oh, okay. All right.
All right.
So are these attorneys for the,
yeah.
I assume the CEO?
Attorneys at law, they're from Tulsa, Oklahoma, or she's writing from Tulsa, Oklahoma.
I'd write back to them and tell them you are not a party with an interest in this trust, and if you breach this trust, I will take appropriate action.
Okay.
Then I would write back to the CEO and ask him, give him an opportunity to cure of a time, say, 10 days, say.
Mm-hmm.
Or else he'll be deemed to be in breach of trust.
Now, should we give him, 3 opportunities to do a complete administrative process?
3 opportunities?
Or
no.
2 more.
Yeah, we just need to give him 1 opportunity to cure before you deem him to be officially, when you send a notice that he would be in breach of trust.
Mm-hmm. So, will a threat to bring him to Court of Equity to explain his position be in order?
Yeah, you could elaborate on that if you wanted a little bit, but...
You may be brought to court.
Yes, to seek relief in this matter, yeah. So-and-so, whatever you're going to do, and then govern yourself accordingly.
Mm-hmm.
And then the next thing after that I would want to probably do would be to put in a notice and demand for the trust res to be returned.
Trust res, yeah.
You could get him on a breach of not doing the duty of the trust, and also get him in a second breach on when you ordered the trust res to be surrendered and released, that he would also be in breach of that. Now that would be the determining factor, that they never return trust res, so thereby they are holding trust res and they are acting as trustee because they're holding it.
Mm-hmm.
Their actions overcome their communications.
Right. Well, they're plainly in the letter denying the fact that there's a trust, and they don't recognize any.
It makes no difference what they deny in writing. The fact is they are holding trust res and operating as trustee on that trust res, whether they like it or not.
Mm-hmm. Well,
no matter what they say, because their actions overrides their writings.
Uh-huh. Well, so far their actions have been in breach of trust.
Their actions of holding and operating as trustee is the proof of their intent that there was a trust.
Mm-hmm. So
they're acting under an acceptance of a trustee headship.
Uh-huh.
And just because they say otherwise is not the record.
Right.
So I'd keep on making records that supports your case from here on in.
Yep.
And keep on bringing them back to that the trust is being breached, and what do they intend to do about it.
Well, apparently they were not wanting to do anything except have their hound dogs.
Yes. Are you on some of the other calls?
Yeah, I know. I think I called you like on a Monday night the last time,
okay.
And I've called you on a Saturday night as well.
Some of the other calls, Chris Summers was talking about some of the other possible things that we could actually mention to them. These wouldn't be threats, because a threat is not something that you cannot, it's not legally possible to do. These are legally possible things, so they're not threats. So you could say, a FinCEN 101 report, I believe it's the SEC 25 form, or is it the 15? I forget anymore. I think it's the 25, the 15, and the FinCEN 101 or 103 or something like that.
Mm-hmm.
Where they could be reported under these things. So I could rattle that sword at them.
Right.
And point out the fact that the comptroller of the currency would be notified, and the SEC in an investigation of where my securities went to. And they have possibility of them losing their banker's license.
Does the FDIC not maintain some kind of control over the trust res that they're holding?
Yeah, that might be something there too. And then you could also put in there, threaten them with antitrust.
Mm-hmm.
But you can't construe it to be a threat, that which can legally be done.
Right. These are all possible consequences of your non-behavior.
Yeah, and I would word that in such a way that I want to prevent you from doing these things. I'm giving you every opportunity to make this right, because we want to achieve the goal of the extinguishment of the debt per the indenture of the trust without a breach to take place. Otherwise, we're going into a court of equity to prevent the breach, say, which would give you maybe even the stronger hand. And there's where it could come in, maybe possibly just to do something quick, and which would be the show cause hearing to prevent them from breaching, and just do a show cause hearing. Why the trustee should be prevented from breaching the trust by mandatory injunction.
Well, that would probably get their attention, if nothing else.
Yes, and then I believe on the last night's call and Monday night's call, or possibly Saturday too, I think where we were started at, we went over the Reed and the Trustee Corpus Juris Secundum, Book 90, on the section on enforcement.
Right.
Those 3 or 4 tapes, possibly last 3 or 4 nights, have been real good informations for causes of action and elements to support causes of action. And it's all in the enforcement section that we started. I forget what section that was.
Have we had very many people try this little exercise?
No, we're just kind of like corresponding to the Reed about where everybody is, starting to be at. So, we're all like on the crest of the wave here, and there is no paperwork in existence, and we're.
I was just wondering if anybody else had, gone to the bank and tried to do what we've done, see what the results might be. I'm wondering if maybe different banks react differently.
Yeah, could be.
This bank is a locally owned bank by one of the big corporations of the United States that everybody knows, probably many hate. I'm sure you've heard of Wally Merle.
Yeah. Okay, we started on section 421, which was the section 7, which is establishment and enforcement of trust. And that was on page 820, and I forget what night that was that we started at. That might have been last Saturday, I believe.
All right.
We had last Saturday, Monday, and Tuesday. So there's been at least three studies starting at that section there over the last 3 nights.
Now, were you also reading from Book 90 this evening?
No, I was reading from the book Lewin's.
Oh, Lewin's book. Okay. Well, okay. I'll get off here and let someone else ask a question. We'll, like I say, as I told you before, we'll keep you posted on this saga.
Okay. Great.
It might get interesting.
I love those letters that you get from the attorneys that say that
deny everything. Yeah.
It has no legal effect whatsoever, and it's frivolous. It's frivolous.
Yeah.
All right, next caller, Jeff. You've been unmuted. Go ahead with your question.
Hello.
Welcome to the call.
All right, thank you. I have a couple of questions about the counter complaint. And what's the difference between cross complaint and counter complaint?
Oh, we got to make a definition.
Hey, Jeff.
Yes.
Hey, when Christian answers, you got a lot of background noise. Is there any way you can mute out or step out to an area where there's not so much background noise?
Yeah. Sorry, hold on.
No problem.
But
Thanks.
*6, right?
Yep.
Okay.
Christian, did you hear that question? What's the difference between a cross complaint and a counter complaint? Is that what he said?
Yeah, I'm looking it up in Black's Law.
Isn't a counter complaint when you get sued and then you basically sue them back and say, yeah, but I'm being injured because of what you did to me, as a scenario, where a cross complaint says, well, yeah, you may be suing me, but it's because this guy over here did this, and so you bring in a third party.
Yeah, I wanted to get the appropriate definition, but,
Absolutely.
Look in the other book here. Didn't see it under complaint. Okay. So let's take, for example, under federal rules, Rule 13. So it says under Rule 13A, it says compulsory counterclaims. A pleading shall state as a counterclaim any claim which at the time of serving the pleading the pleader has against any opposing party if it arises out of the transaction or occurrence that is the subject matter of the opposing party's claim and does not require for its adjudication the presence of third parties of whom the court cannot acquire jurisdiction. Okay, cross-claim is 13G, cross-claim against co-party. A pleading may state as a cross-claim any claim by one party against a co-party arising out of the transaction or occurrence that is the subject matter either of the original action or of a counterclaim therein or relating to any property that is subject matter of the original action. Such cross-claim may include a claim that the party against whom it is asserted is or may be liable to the cross-claimant for all or part of the claim asserted in the action against the cross-claimant. So basically just what you said there, Matt. So.
Hello? Am I still on the call?
Yeah.
Yes.
Okay, great. Yeah. So I guess I was trying to understand the when you do a cross complaint or a counter complaint, I guess more a counter complaint, are you rebutting as well as making a separate claim that, well, there's trust here, but I'm going to rebut all your colorable public accusations and then rebut all that and then put in your real claim that this is a trust? So you basically make a pleading rebutting their colorable claims or their accusations, and then you go ahead and put in not only that, but it's a trust, and then you include the SOI with it to prove it. Does that make sense what I'm saying? Hello?
You know what? We might have lost Christian.
Oh, shoot. Did we?
Yeah, we did lose him. He'll dial back in here in a sec.
Did you get the question I was asking?
You know, I have a foreclosure that I'm fighting right now on my house, and we put in a summons and complaint that basically
A counter complaint?
Well, we put in a complaint because
Right.
Minnesota is a non-judicial state, so they did foreclosure through a sheriff's sale. And we were fighting against the attorneys, letting them know, you're not following the Fair Debt Collection Practices Act, and you're in violation of it, and, you need to validate and verify the claim of the debt that I was disputing, which of course they didn't do. They just ramrodded and railroaded me, and went ahead and had the sheriff sale anyways. And so after the sheriff sale on the last day of my redemption period, I put in a summons and complaint in there. I think we had 8 counts against the bank stating, that the foreclosure was fraudulent, blah, 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 blah. And it was 55 pages long. Well, here's what happened. The bank that we sued had their servicer's counsel answer the complaint.
Right.
And so they answered it by denying everything. Now remember, the defendant didn't answer. The defendant's servicer's counsel answered. Now the servicer isn't part of the transaction. Why in the world are they answering this complaint? Well, they went ahead and denied everything, and then they put in a counterclaim stating that they have been injured because I'm still in the house, and I am stopping their right to legally, take over the house.
Right.
And so they're being injured, and so that was a good example of a counterclaim.
Wow.
So basically they're turning around and suing me, and so now we have to answer their counterclaim. Because they aren't even part of the transaction, Minnesota Rules Procedure 12 and Rule 17, the court has no jurisdiction over this party because they're not the real party in interest. They're not the holder in due course. They don't have any evidence that they are holding the note and the mortgage. And so, I put a motion to dismiss their counterclaim in, stating those reasons.
Right.
Now, a cross-claim would be them then, let's say the bank that I sued turned around and sued Greenpoint Mortgage, who was the originator of the loan, and said, well, maybe we foreclosed fraudulently, but Greenpoint, they had a fraudulent loan from the beginning, so we're suing them. That would be, I think, in my opinion, a cross-claim. Where they're adding that third party. Right.
Right. Okay. That makes sense. But I guess really, my question was kind of twofold. One, the difference between it bringing a third party in, and two, when there is a complaint against you and you want to have a counter complaint, do you rebut all their accusations and assumptions, or do you just basically put your issue on top, which is there's a trust here, and you might bring all these colorable claims, but all those colorable claims are irrelevant because this is a trust anyways. I mean, do you bother even acknowledging their colorable claims, their accusations essentially say they have 50 points of that causes of action? Do you have to address all those causes of action? Or can you just basically make your own claim up on top and forget even addressing or rebutting their claim?
Right where you're asking a question, Christian just jumped back on. Christian, did you catch that last question?
Yeah. I would think it would depend on whether or not the tolling of the time stops, whether you had to answer or not. Some jurisdictions is a little bit different, so you've got to almost check with your local rules. But I would say it would be safe to say that you really should answer the complaint within the 20 days, their counterclaim, or else they'll default you, even though they don't even have standing. Because that's an unproven issue just yet.
Yeah, I understand. So basically, once you answer, though, then you put in a counterclaim. At that point, say you answer, but then you put in your counterclaim after that. So then you don't need to readdress. You don't have to go back to their accusations again. You can just go ahead and put your counterclaim and stick on your issue, which is basically this is a trust, and here's the NOI, which is my claim, and then the SOI to prove there's a trust. So basically putting that on top, not going back to rebut all their assumptions again. You know what I'm saying?
Yeah,
that make sense?
But yours is on top. The last counterclaim is on top, so that's got to be first.
Yeah. Okay. All right. That makes sense. Okay. Well, thanks a lot, you guys. Great call.
Thanks for calling in. Okay. All right. Well, hey, it is 10 o'clock Eastern. We're going to wrap it up for the night, but thank you, everybody, for joining us on the call. Christian, as always, thank you for sharing your wisdom and going through the new trust technology. Folks, tune in next week for another call next Wednesday night, same time, 8 p.m. Eastern. Thanks again, Christian. Have a great evening.
Have a great. Thanks.
Night, everybody.